leave a will. And in these circumstances, okay, if let's say they don't have any money, which is impossible, if they don't have any money, that is okay. But if they do have some money, they do have some asset, and that could be property, cars, or even debts,
land,
yeah.
yes.
Okay, so what will happen to all this asset? Let's say, for example, it is a woman who passed away or wife who passed away. What will happen to the asset?
If there is no will, just like Vicky is saying, if there is no will, okay, that what will happen is that the Distribution Act will be applicable.
Okay.
What will happen is that before I actually go into this thing, I would like to share a very interesting statistics. Did you know that as of late 2020, there is up to 70 billion ringgit worth of assets that is unclaimed? Yes, Vicky is right. Unclaimed assets up to 70 billion ringgit worth of assets. And this is inclusive of EPF money with no nominators, insurance money. This is also inclusive of saving accounts, current accounts. This is inclusive of also land and property as well, and also cars. So, this is a very interesting statistics itself. So, and one of the reason is because there were no wills prepared, or in this type of circumstances here, they are stuck in legal procedures as well. So, to go back to your question, right, Vicky, what happens when there is no will prepared is that when a woman passes away, is that then they will have to ask, the first question they will have to ask is whether or not she has got children or not. Okay, whether she has children.
She has children.
Okay, she has children. Okay, if that's the case, then right, you have to look at the Distribution Act itself. Okay, under the Distribution Act has already fixed the certain amount that is to be given to the children and a certain amount to be given to the husband, and whether or not, okay, then in these type of circumstances you have to ask whether or not does the woman who passed away, does she have parents?
Okay, what if she does have parents?
If she does have parents, right, the Distribution Act would also already fix the amount of assets to be distributed to the parent. So it doesn't matter whether or not she want to give it to them, the Distribution Act has already fixed it. This is for non-Muslims. I just like to emphasize this again.
So Muslim, again, you have to refer to Sharia law.
Yes, correct.
Yes. Okay, so which means all this while I thought that if the woman passed away, it's only referring to immediate family, which is the husband and the children.
Correct.
But it's not that just the children and the husband, but also to the parents as well.
Yes.
So will the in-law get any part of the assets?
No, because under the Distribution Act, they only look at your parents, they look at your immediate parents, then they look at your spouse, which is your husband or your wife, and then your children. Those are the ones that will be benefiting from the Distribution Act. They have already fixed it. It's only if you don't have a husband, you don't have children, and you don't have parents, then your money will then be distributed to others who will then have to claim it they will have to apply to court to claim it as well.
I see. So which means there are so many people, could be, they are not married, and they don't have children, they don't have parents, they probably have aunties or uncles or nephew or whichever who doesn't want to go and claim their property.
Maybe they are not aware. Either they are not aware, because you see, these kind of things you don't know when there is no will prepared, right? Also, we also do not know whether what are the assets that the member has that has passed away.
I see. Okay, that is very dangerous, especially if some people think that, I'm not married, I don't have children, I don't have husband, I don't have wife, so I don't need to prepare a will. So which means if you're unmarried, you are not married, and you do not have a children, you really need to prepare a will. Am I right?
I mean, I think it's important to prepare a will because there's another thing is that the legal procedures are also different. I will actually share more about this later, but what I would like to say is that there is actually, if there is a will, then at least there is certainty in the distribution. And you have the certainty to know that the assets that you have gathered, right, will not be given to any of your relatives or your loved ones which you do not wish to give, and you can control the volume or the amount of assets that you want to give to each family member or your loved ones.
Okay, so let's move on to the other part, which let's say the man passed away. the husband passed away.
I want to tell you, when the husband passed away and there is no will also as well, and this is for non-Muslim again, I like to emphasize, the Distribution Act again will apply. Okay?
Okay.
Yeah.
Will they apply to the children first or the wife
No,
first?
they have already been fixed. The amount of share given is already allocated. It is fixed in statute, and well, you cannot escape that. There's no, you cannot later say that I want to give more to my husband. No, no such thing. They all will be given the fixed amount of assets in accordance to the Distribution Act.
Okay, now talk about will.
Yes.
I know a lot of you are very curious as much as I'm curious. As a woman, okay.
Yes.
Okay, so the moral of the story is never go on live with your wife.
Yes.
Yeah?
Yes.
Do you acknowledge your mistake?
Yeah.
Okay, now I have another question. So why is this will very important? So much that we talk about it. Okay, a lot of people knows that I need to write a will, but there are also people which are very stubborn because either they are stubborn or they don't know how to write a will.
Yeah.
Okay, like another Vicky, how
Yeah.
will appear in your life. Why should I write a will? I don't need a will. I'm still young. Or the person has totally don't know how to write a will, because as far as I'm concerned, anyone can write a will. Even you yourself can write a will without legal knowledge. But then how far can you go into writing a will? And second of all, what kind of things do I need to distribute? And why is it so important about writing a will?
Okay, before I go into this, right, I would like to again highlight on the Distribution Act. So for example, let's just say that for whatever reason, for whatever reason there is you and your loved one has a divorce, right? And then after that, he then gets married again, but he fails to prepare a will. In this type of circumstances, right? So then the assets will not only be distributed to your, let's just say if you have children, it will also be distributed to the new wife and also the children of the between the husband and the new wife as well also. So that is what in this type of circumstances, it's also important to prepare a will, because then you can actually ascertain how much is to be distributed to each of the family members.
I see.
Yeah. So
Okay.
now to answer your question, I'm sorry, I've actually forgotten your question already. Can you repeat
I
your
also
question?
forgot my bad.
Okay. Yeah. All right.
Okay, by the way, I have a student say, you get it all, Vicky.
Yeah.
You know, if I think her question, her message to me is
Yes.
when the husband passed away, I'll get it all. That's
that-
what I heard as well from my mother.
Yes. Again, as I said, right, I mean, jokes aside, right, to answer your question, right, when will, or how easy is it to prepare a will? Actually, just now I remembered your question already.
Okay.
Yeah, it is actually very easy to prepare a will. But it is advisable to go to your lawyers and to get them on, or right now those professional will writers. Okay, for now I would say that you go to your lawyers and professional will writers who actually are paid to do such work, and they will be able to draft the will which would be in accordance to your instructions. And then as you said earlier, you don't know what can be included in the will, what you can't include in the will. So they would know very well. They will be able to advise you, okay, your saving accounts, what are your current accounts, your cars, your loans, okay, what are the debts that is outstanding. So you must remember that the will can only specify the remaining assets. That means is that after a person has passed away already, right? Then any of the asset is consists of the remaining assets after deducting all the liabilities under the estate itself. So the person who passed away, his estate, we call it his the estate. It will consist only of the balance assets. So what type of assets is I will again reiterate, it would be all the current assets. It could be cash, jewelries, it could be all the belongings, personal belongings of your loved one or your relative or your close friends. It also could be it could be also cars, land and property itself. So these are all that. EPF money normally, if they will already specify that they will request you to nominate a party inside the EPF itself, and filling which then you will have to produce the grant of probate, which I will discuss further later once you have prepared the will. So they will request for all of this. Only then they will allow the distribution. And insurance as well. There's also they will also nominate already who are the parties and how much they will get. Normally, when you sign the insurance agreement, the time they will already specify who are the parties you wish to nominate as the beneficiary upon anything happening to you or your loved ones at that type of situations.
It's a very serious
Correct.
business. It's really a serious business. But you advise us to get a lawyer. So my lawyer is.
Yeah. It really depends. You know, you can if you are.
So I'm asking my husband to drop my bill for me.
Yeah.
So I have more debts than I have more assets.
Yeah. But it in this type of circumstances, it's always better. I mean, for you to go to your family lawyer if you have one and seek their legal advice if you have a family lawyer in that situation. And normally that would be not it should be best not to get someone who would be a beneficiary as well, who then can draft the will for you and then get two parties to witness it that are not related, who are not beneficiaries, or the person that has been appointed as the trustee itself.
Okay. So I have Ivy here say, but the assets still owing.
Yeah.
Is it calculate will? Is it calculate will? So I just assume Ivy's question could be if the assets still have owing,
Yeah.
so which